Hello, my name is Kirstin Cole. The video you're about to view was produced by the Connecticut Chapter of the American Academy of Matrimonial Lawyers, and it's designed to give you a very general overview of the divorce process in Connecticut and some basic information about issues related to domestic violence. It is not meant as a substitute to consulting with and hiring a qualified lawyer who is experienced in matrimonial law. All fellows of the Academy have practiced matrimonial law for at least 10 years. They are required to present positive recommendations from other attorneys as well as judges, and they've passed a rigorous written exam involving state and federal laws relating to the practice. At the end of this video, you'll find a list of pamphlets authored by the Academy. All are available through our website. We hope they will be of further assistance to you and that you find this video helpful. Thank you. Finding the right family lawyer is perhaps the most daunting but most important part of the family law process. During the divorce process, you will likely receive unsolicited advice from all sources: family members, friends, and mere acquaintances. The most important advice will come from the attorney that you select, so you need to choose carefully. All too often, when people try to do it themselves, they find out much later that what they did was wrong. Almost invariably, it is a mistake to represent yourself. There are several steps you should take before you meet with an attorney. Make a list of your assets, liabilities, and income. Determine the amount of your monthly expenses. Before your scheduled appointment, make a list of questions for the attorney. Additionally, you should bring all papers, tax returns, end-of-the-year brokerage statements, and other financial documents that you think will be relevant to your case with you when you have your first meeting with the attorney. By doing preliminary work yourself, gathering those documents and information, you will cut down on the time that your lawyer is going to have to spend gathering that information. Always remember that it is very important to tell your lawyer all of the facts, good and bad. He or she must know everything about your matter if a determination is to be made about your case, but know that your lawyer must keep the facts in the strictest confidence. If you bring a friend or relative with you when you meet with the attorney, the information you provide during the meeting will not be considered privileged or confidential. In the last decade, several methods of alternative dispute resolution, or ADR, have become popular. These include collaborative law, mediation, and arbitration. The attorneys who include these options in their practice are specially trained. You should ask your attorney to explain these options and describe the benefits and the risks of each one of them, in addition to the benefits and risks of using the traditional litigation process. If you decide to use a mediator, make sure that he or she is experienced in mediation and familiar with the law in your jurisdiction. For many clients, a significant concern when searching for a matrimonial attorney is the cost. A straight hourly rate fee arrangement is the most common type of fee structure. In this situation, your lawyer will require you to pay part of the fee in advance or upfront. This is called a retainer. This retainer is a deposit or down payment to make sure that the client is prepared to pay for the lawyer's time. The amount of the retainer payment will vary from case to case and from lawyer to lawyer. Of course, your individual financial situation and the experience, reputation, and ability of the lawyers performing the services usually determines the amount of the retainer that the lawyer will request. For example, if you have substantial wealth and you are in a child custody battle with your spouse, chances are your lawyer will want a larger retainer than if you have a situation in which the financial issues are simple, there are no issues concerning children, and you only need your lawyer to prepare the documents to process the divorce. The latter situation is generally referred to as an uncontested divorce. While clients want to know how much the divorce will cost, most lawyers won't be able to give a precise figure, since the amount depends on the total time spent. Lawyers' billable hours usually range from $250 to $800 per hour, depending on the lawyer and the geographic area in which he or she practices. Divorces can typically cost anywhere from approximately $1,500 plus court fees and disbursements for the simplest uncontested divorces to tens or even hundreds of thousands of dollars. They can even cost millions of dollars in very complex matters. As Abraham Lincoln said, "A lawyer's time and advice is his stock in trade." A lawyer sells his or her experience and training. Before being allowed to practice law, a lawyer must have satisfied certain criteria, ranging from having successfully completed 3 years of law school to having passed the state bar examination. These requirements have been established to protect the public from being represented by unqualified individuals. Unlike a shop owner, an attorney sells knowledge to his or her client regarding how to accomplish a specific goal. In Connecticut, experienced attorneys who have passed both a state and national exam are eligible for membership in the American Academy of Matrimonial Lawyers, or AAML, a select national organization of 1,500 members who are considered experts in the practice of family law. In Connecticut, a lawyer must provide you with a written letter of engagement and/or a written retainer agreement that describes fee arrangements and states the rights and responsibilities of both the client and the attorney. A retainer agreement is a contract setting forth the services to be performed and the fees to be paid. Both the attorney and the client sign the retainer agreement. You should read this retainer agreement drafted by your attorney carefully before you sign it, and feel free to ask the lawyer any questions you have about the letter. This retainer agreement between you and your lawyer is a contract, which, among other things, sets forth how the fee will be determined. It is important to remember that although you can ask the court to order your spouse to make a contribution towards your attorney fees, such awards are not mandatory or automatic. In other words, you are responsible for the payment of the fees you incur. You should ask your attorney some background questions to get an idea of whether he or she possesses the knowledge and experience you need for your particular case. For example, you may want to ask, how long have you been practicing law? How long have you been practicing family law? In which courts do you routinely practice? Is your practice exclusively family law? How do you get along with other lawyers? How do you use associates, paralegals, or a client to keep costs down and enhance your work on cases? Will you be the attorney who goes to court with me, or will an associate? Do you have any specialized training? What is your policy regarding email and phone calls? What client handouts do you have that will be of assistance? How can you help me with my case? What is the minimum billing unit? 6 minutes, 10 minutes, or something else? Do you anticipate the need to hire experts? Inquire about what steps your attorney expects to take and how much time and money they anticipate spending. An experienced lawyer should be able to outline the process for you with a fair degree of accuracy. Although many cases are quickly resolved by agreement, called an uncontested case, many other cases take a long time. However, only a small percentage of family cases actually will get resolved only after a trial by a judge, not a jury. Don't expect an attorney to quote a dollar amount as to the entire fee. In fact, be wary of an attorney who promises to handle your case for a fixed sum, since it is impossible to tell how much time and effort will be required in all but the most routine, uncontested divorce cases. You and your spouse will each have a right to independent legal counsel in a divorce situation, regardless of whether you and your spouse agreed to keep the divorce friendly. While you and your spouse may enter into the divorce process expecting to resolve things amicably, there is always the possibility that problems will occur during the process. Accordingly, each party should have his or her own attorney. One lawyer is not permitted to represent both sides. One person cannot serve two masters effectively, and the courts do not allow one attorney to draw up a separation agreement for both parties. Courts have concluded that it is improper to represent both sides in a matrimonial action, even with consent and full disclosure. Remember, if you are uncomfortable with the first attorney with whom you consult, either because of his or her seeming indifference, inexperience, or just plain bad vibes, feel free to consult with another well-recommended attorney. The selection of a family law attorney is too important to be treated casually. Each state has its own requirements to be able to file for a divorce. The following are some of the terms or information you need to know. One of the parties must be a resident of Connecticut at the time of filing. Connecticut requires that one party has been a resident for 12 months prior to granting the decree in order to qualify to obtain a divorce. You need not have lived in Connecticut before you can file for a divorce. However, no final judgment can be granted unless one party satisfies the residence requirement of 12 months. It is helpful to have a local driver's license, voter registration, tax returns, real estate deeds or leases, proof of where mail is received, and receipts from stores and restaurants in order to substantiate that you live in Connecticut so that your residency cannot be challenged. What happens if you have not lived long enough in Connecticut to file for divorce? If you have not lived in Connecticut long enough to be considered a resident for the purposes of divorce and your marriage is in trouble, most states will allow you to seek relief in other ways. Though divorce may not be an immediate option, an action of temporary child support, temporary alimony, and temporary custody are. What if you and your spouse live in different states? If you and your spouse live in different states, a court may have to make a factual determination as to which state has authority to grant a divorce. Generally speaking, the last place you lived with your spouse will have jurisdiction over the marriage unless both parties have moved away from that state. Do I have to file for the divorce in the county where we live? Connecticut generally requires that the divorce action be filed in the county where the person who is being sued for divorce lives. The legal term is venue. What role does fault play in a divorce? In Connecticut, you can obtain a divorce by reason of irretrievable breakdown of the marriage with no hope of reconciliation. Fault, or what someone may have done wrong during the marriage, becomes an issue in Connecticut only if the conduct caused or contributed to the breakdown of the marriage.